Hey, it's Kiko here, and today I wanted to talk about the Working Families Flexibility Act of 2017, code HR 1180 of the 115th Congress. It was, proposed by Representative Martha Robbie, Republican of Alabama, 2nd District. And I first saw this in the news from places like the Washington Post, who still has Democracy Dies in Darkness on the front, and Huffington Post. And let's just read a quick section from Huffington Post, where it's very, very harsh on this bill. And when I first read stuff like this, I hadn't actually read the bill yet. It says, much like a wolf in sheep's clothing, the falsely cloaked Working Families Flexibility Act would hurt, not help working women and families. The Working Families Flexibility Act, a true misnomer if there ever was one, would in reality ensure that workers have less time, less flexibility, and less money. I love this one next. This anti-family proposal would force workers to spend more time away from their families in exchange for possibly getting to spend time later with their families. Under this proposal, the employer, not the employee, would determine when earned comp time can be used. All right, so that's what they have to say about that. The bill, which supporters say would add flexibility to hourly worker schedules, while opponents worry that it wouldn't do enough to protect warriors, is not a new idea. So they seem to be a bit, chiller about it than the Huffington Post. But let's actually read what it has to say. So, an act to amend the Fair Labor Standards Act of 1938 to provide compensatory time for employees in the private sector. So this is, an act under President FDR, which was during, the Great Depression and when they really needed to ensure that people had fair rights. So they're going to amend this, and that's not entirely unheard of. Every time they want to add more protections, or in some cases remove protections, they have to amend this. Be it enacted by the Senate and House of Representatives of the United States Congress of America and Congress assembled, Section 1 short title. So this is the little catchphrase, short name to market this. This act may be cited as the Working Families Flexibility Act of 2017. Section 2, compensatory time. This is when we start getting into the actual meat of what this bill is. Section 7 of the Fair Labor Standards Act is amended by adding at the end the following. So this is not removing anything from the protections. Compensatory time off for private employees. 1. General rule. An employee may receive, in accordance with this subsection and in lieu of monetary overtime compensation, compensatory time off at a rate not less than 1.5 hours for each hour of employment for which overtime compensation is required by this section. So let's say, this is pretty much saying, let's say I work 1 hour overtime. I could, instead of getting paid overtime, I could instead be given 1.5 hours, so 150% of my time off at another time. If I, did that for 8 hours, or I did 16 hours of overtime, I would be able to just switch that in for a full 8 hours off, for pretty much a full day. 2. Conditions. An employer may provide compensatory time to employees under paragraph 1 only if such time is provided in accordance with A. Applicable provisions of a collective bargaining agreement between the employer and the labor organization that has been certified or recognized as the representative of the employees under applicable law. So this says you can do it if there are provisions for it in a collective bargaining agreement between the company and the union that the worker is under. Or B, in the case of an employee who is not represented by a labor organization or union that has been certified or recognized as the representative of such employee under applicable law, an agreement arrived at between the employer and employee before the performance of the work and affirmed by a written or otherwise verifiable record maintained in accordance with Section 11C. I'll get to that in a second. This is basically saying that the only case in which an employer could do this was if an agreement arrived at between the employer and employee before the performance of the work, affirmed by a written or otherwise verifiable record maintained in accordance with this section. This is basically saying that they can only do it if you agree to it. And then they're saying maintained in accordance with Section 11C, in which the employer has offered and the employee has chosen to receive compensatory time in lieu of monetary overtime compensation and entered into knowingly and voluntarily by such employee and not as a condition of employment. This is a big one. So this is saying the employee can choose between the two and is fully aware of what this law means and entered into knowingly and voluntarily, and you cannot refuse to employ someone if they don't want to do it. Next section. No employee may receive or agree to receive compensatory time off under this subsection unless the employee has worked at least 1,000 hours for the employee's employer during a period of continuous employment within the employer in the 12-month period before the date of agreement or receipt of compensatory that's such a hard word. Compensatory time off. So this isn't something that happens off right away. Let's say you get a new job. You won't have this option available to you until you've worked for at least 1,000 hours for that employer. Section 3 is the hour limit, which actually sets, here, Section A, maximum hours. An employee may accrue not more than 160 hours of compensatory time. B, compensation date. Not later than January 31st of each calendar year, the employee's employer shall provide monetary compensation, which means if it's like before January 31st of the calendar year, the employee has to provide the money at regular overtime rates, 150%. For any unused time accrued during the preceding year that was not used prior to December 31st of the preceding year at the rate described by paragraph 6, which is 1 1/2 of the rate. An employer may designate and communicate to the employer's employees a 12-month period other than the calendar year. So let's say at the time that you were hired, and January 31st is a bit of an awkward time, you can set a different 12-month span for that to happen. An employer may designate and communicate the 12-month period other than the calendar year, in which case such compensation shall be provided not later than 31 days after the end of such 12-month period. See excess of 80 hours. The employer may provide monetary compensation for an employee's unused compensatory time in excess of 80 hours at any time after giving the employee at least 30 days' notice. Such compensation shall be provided at the rate described by paragraph 6. So again, 1 1/2 the rate. D, policy. Except where a collective bargaining agreement, except where a union has stepped in, an employer that has adopted a policy offering compensatory time to employees may discontinue such policy upon giving employees 30 days notice. So if they ever want to end this agreement, the employee gets 30 days before that happens to come to terms with everything and get everything set up. E, written request. An employee may withdraw an agreement described in paragraph 2B at any time. An employee may also request in writing that monetary compensation be provided at any time for all compensatory time accrued that has not yet been used. Within 30 days of receiving the written request, the employer shall provide the employee the monetary compensation due in accordance with paragraph 6. So this is saying that if the employee at any time needs that money and doesn't want to use it as time off, they can submit a written request, and the employer must, within 30 days, give all of that money at the rate described in paragraph 6, 1 1/2 their regular rate. Section 4. This is the next section. Private employer actions. An employer that provides compensatory time under paragraph 1 to an employee shall not directly or indirectly intimidate, threaten, or coerce, or attempt to intimidate, threaten, or coerce any employee for the purpose of A. Interfering with such employee's rights under this subsection to request or not request compensatory time off in lieu of payment or monetary overtime compensation for overtime hours, or B. requiring any employee to use such compensatory time, as in a way to get out of paying them if they don't use it. 5. Termination of employment. This is another big one. An employee who has accrued compensatory time off authorized to be provided under paragraph 1 shall, upon the voluntary or involuntary termination of employment, be paid for the unused compensatory time in accordance with paragraph 6. This is saying that if you quit or are fired, that the company must give you the monetary compensation for all the time that you did not use. 6. This is the rate of compensation, which they've been referring to several times. A general rule of compensation is to be paid to an employee for accrued compensatory time off. Such compensation shall be paid at a rate of compensation not less than the regular rate earned by such employee when the compensation time was accrued, or the regular rate earned by such employee at the time such employee received payment of such compensation, whichever is higher. So again, you're making sure that whatever rate is higher. B. Consideration of payment. Any payment owed to an employee under this subsection for unused compensatory time should be considered unpaid overtime compensation. 7. Use of time. An employee who has accrued compensatory time off authorized to be provided under paragraph 1, and B. who has requested the use of such compensatory time shall be permitted by the employee's employer to use such time within a reasonable period after making the request, if the use of the compensatory time does not unduly disrupt the operations of the employer. This is basically saying that you can use the time essentially whenever, so long as you give your employer good time. The one issue that I have with this section, though, is that it doesn't set any maximum amount of time. I'd like it if the bill included a section that said the employer must grant you this time within 7 days, let's say. It could come up to a judge's personal interpretation of what the term reasonable period might be. But I would hope that judges would be reasonable when talking about reasonable periods. 8. Definitions. For purposes of this subsection, the term employee does not include any employee of a public agency. So this does not apply to people who work for the government or state government or anything like that, the post office, for instance. It does not apply to them. B. The terms overtime compensation and compensatory time shall have the meanings given such terms by subsection O, subsection O, section 7. Section 3. Remedies. Section 16 of the Fair Labor Standards Act of 1938, which is what we talked about earlier, is amended in subsection by striking quote, B, any employer, and inserting B, except as provided in subsection F, any employer. All right, so this is making an exception. I'm not quite sure. And by adding at the end the following, I'm not sure exactly what that would change. And by adding at the following, F. Oh, so this is the subsection that they're talking about. This is what they're referencing in this section. An employer that violates section 7S4 shall be liable to the employee affected in the amount of the rate of compensation determined in accordance with Section 7, subsection 6A, for each hour of compensatory time accrued by the employee, and an additional equal amount as liquidated damages reduced by the amount of such rate of compensation for each hour of compensatory time used by such employee. Which means that if an employer violates the things in this bill, that they shall be liable to the employee affected in the amount and rate of compensation determined in paragraph 6 for each hour. So if they ever violate this, they have to pay you. A judge will force them to pay the employee. Section 4, notice to employees. So this is referring to the workers. Not later than 30 days after the date of the enactment of this act, so 30 days after the president signs this, the Secretary of Labor shall revise the materials the Secretary provides under regulations published in Section 516.4 of Title 29 Code of Federal Regulations to employers for purposes of a notice explaining the Fair Labor Standards Act of 1938 to employees, so that such notice reflects the amendments made to such act by this act. Is basically saying that not later than 30 days, within 30 days of the president signing this bill, the secretary must create and provide materials to explain to employees what has changed and what rights they have under this and what they can do. It informs them of their rights. Section 5, the GAO report, which is, I don't remember what GAO stands for. Beginning 2 years after the date of enactment of this act, and each of the 3 years thereafter, the Comptroller General of the United States shall submit a report to Congress providing, with respect to the reporting period immediately prior to each such report, when data concerning the extent to which employers provide compensatory time, the number of I'm just going to skim through this real quick. The number of complaints alleging a violation of such section filed by employees with the Secretary of Labor, the number of enforcement actions, the disposition or status of such complaints, and account of any unpaid wages, damages, penalties, and injunctive. This is basically collecting information that beginning 2 years after the enactment, when the president signs this, and every 3 years after, the Comptroller General will submit a report to Congress telling them the numbers of this bill, how many people are using the rights given to them in this, how much money is involved, how many times people violate this law, how many times people are, charged in violation, how many complaints there are and actions taken against this. And then section 6, the sunset, which is basically saying anything that happens after this act is enacted shall cease to be in effect on the date that was 5 years after the president signs this act. And this passed the House. Today is the 7th of May, so this passed it 5 days ago, May 2nd, 2017, and then attested by Karen Haas, who's the House Clerk. Thank you very much for watching.